CIR versus British Overseas Airways Corporation. GR number L65773, April 30, 1987. Facts. BOAC operates air transportation service and sells transportation tickets over the routes of the other airline members. It had no landing rights and was not granted a certificate of public convenience, which are both necessary to operate in the Philippines, except for a 9-month period, partly in 1961 and partly in 1962, when it was granted a temporary landing permit. It did not carry passengers and or cargo to or from the Philippines, although during the period covered by the assessments, it maintained a general sales agent in the Philippines, which was responsible for selling BOAC tickets covering passengers and cargoes. CIR assessed BOAC with an aggregate amount of 2,498,358.56 for deficiency income taxes covering 1959 to 1963. BOAC protested, and after subsequent investigation, it resulted to the new assessment of 858,307.79, which BOAC paid but in protest. BOAC was again assessed, this time for the 2 fiscal years covering 1968 to 1971, with the amount of 549,327.43 for deficiency income taxes, interest and penalty, plus compromise penalties. BOAC requested that it be countermanded and set aside, which the CIR denied. The tax court held that proceeds of sales of BOAC passage tickets in the Philippines do not constitute BOAC income from Philippine sources, since no service of carriage of passengers or freight was performed by BOAC within the Philippines, and therefore said income is not subject to Philippine income tax. The Court of Tax Appeals' position was that income from transportation is income from services, so that the place where services are rendered determines the source. Tax court ordered petitioner to credit BOAC with the sum of 857,307.79 and to cancel the deficiency income tax assessments against BOAC in the amount of 534,132.08 for the fiscal years 1968 to 1969 and to 1970 to 71. A petition for review and certiorari of the decision of tax court was filed. The issue in this case is whether or not during the fiscal years in question, BOAC is a resident foreign corporation doing business in the Philippines. And the ruling of the court is yes, BOAC is a resident foreign corporation doing business in the Philippines. It is our considered opinion that BOAC is a resident foreign corporation, the court said. There is no specific criterion as to what constitutes doing or engaging in or transacting business. Each case must be judged in the light of its peculiar environmental circumstances. The term implies a continuity of commercial dealings and arrangements and contemplates to that extent the performance of acts or works or the exercise of some of the functions normally incident to and in progressive prosecution of commercial gain or for the purpose and object of the business organization. In order that a foreign corporation may be regarded as doing business within a state, there must be continuity of conduct and intention to establish a continuous business, such as the appointment of a local agent and not one of a temporary character. BOAC, during the periods covered by the subject assessments, maintained a general sales agent in the Philippines, and that general sales agent from 1959 to 1971 was engaged in, number 1, selling and issuing tickets, number 2, breaking down the whole trip into a series of trips, each trip in the series of corresponding to a different airline company, 3, receiving the fare from the whole trip, and 4, consequently allocating to the various airline companies on the basis of their participation in the services rendered through the mode of interline settlement as prescribed by Article 6 of the resolution number 850 of the IATA agreement. Those activities were in exercise of the functions which are normally incident to and are in progressive pursuit of the purpose and object of its organization as an international air carrier. In fact, the regular sale of tickets, its main activity, is the very lifeblood of the airline business, the generation of sales being the paramount objective. There should be no doubt then that BOAC was engaged in business in the Philippines through a local agent during the period covered by the assessments. Accordingly, it is a resident foreign corporation subject to tax upon its total net income received in the preceding taxable year from all sources within the Philippines. The source of an income is the property, activity, or service that produce the income. For the source of income to be considered as coming from the Philippines, it is sufficient that the income is derived from the activity within the Philippines. In BOAC's case, the sale of tickets in the Philippines is the activity that produces the income. The tickets exchange hands here in the Philippines, and payments for fares were also made here in the Philippines in Philippine currency. The site of the source of payments is in the Philippines, or the Philippines. The flow of wealth proceeded from and occurred within Philippine territory, enjoying the protection accorded by the Philippine government. In consideration of such protection, the flow of wealth should share the burden of supporting the government. Absence of flight operations to and from Philippines is not determinative of the source of income or the site of income taxation. The appeal decision of the Court of Tax Appeals is hereby set aside, and the private respondent, British Overseas Airways Corporation, or BOAC, is hereby ordered to pay amount of 534,132.08 as deficiency income tax for fiscal years 1968 to 1969 and 1970 to 71, plus 5% surcharge and 1% monthly interest from April 16, 1972 for a period not to exceed 3 years in accordance with the tax code. The BOAC claim for refund in the amount of 858,307.79 is hereby denied.